On Monday, the U.S. Supreme Court will hear arguments in a case out of Grants Pass, and it could set a new precedent for homeless camping across the country.
In our Oregon in Crisis coverage, like many communities, Grants Pass has struggled for years with a growing homeless population. A decade ago, city council members discussed how to make it uncomfortable enough in the city so they will want to move on down the road. From 2013 to 2018, the city issued 500 citations for camping or sleeping in public, including in vehicles. Fines were in the hundreds of dollars. Well, a group of homeless people sued the city, and the Ninth Circuit Court of Appeals ruled that the anti-camping ordinance violated another similar case, Martin v. Boise, and that laid the groundwork for recent homeless policy all across the West.
Now, in that case, the court ruled you can't punish people for sleeping outside if they have nowhere else to go, like a shelter. Martin versus Boise is the reason police can't arrest homeless people if they aren't committing any other crimes. Grants Pass doesn't really have shelter space available apart from a transitional housing program run by a religious organization. To go there, you have to follow their rules, which includes participating in their Christian religious practices. So on Monday, the U.S. Supreme Court will be deciding if fining homeless people for public camping violates the Eighth Amendment as cruel and unusual punishment. The city's attorneys appealed the case up to the court, saying that the Martin case has vast unintended consequences on the homeless crisis for a lot of cities.
Yeah, and in their latest and final brief to the court ahead of Monday, they wrote, "This court can see the track record under Martin in the Ninth Circuit, sprawling encampments, rising deaths, and widespread harms to the community as localities are forced to surrender their public spaces. For the past 5 years, Martin has tied the hands of public officials in responding to the homeless crisis and tasked federal judges with making difficult decisions on complex policy issues. They say the Eighth Amendment supplies no workable standards to determine who is involuntarily homeless, what shelter is accessible, or when public camping prohibitions qualify as time, place, and manner restrictions." And they go on to argue that people who are homeless are not forced to sleep on public property, and the Eighth Amendment has nothing to do with public camping laws. They also say encampments threaten the rest of society with sanitation problems and fire danger. But now attorneys for homeless people argue the city is trying to punish them for being homeless.
In their brief, they wrote, although the ordinances purport to criminalize the conduct of camping, punishing homeless people for resting or sleeping outside anywhere at any time when they have no access to shelter and need a blanket to survive is not the punishment of conduct in any meaningful sense of the word. It is akin to punishing the conduct of breathing outside as a homeless person. A ruling from the court will likely take months.